Ms. Mellon.
SJC-10455, Knight versus Beauregard.
Good morning, Mr. Bryant.
Good morning, Chief Justice. Good morning, honorable members. My name is Eric Bryant, and I represent the petitioner in this matter, Stephen Knight, and may it please the court. This is a case that involves the application or misapplication of the lost will presumption as it applies.
Yeah, I'm sorry to interrupt you, but just so we're all on the same page, I'm looking at the judge's findings. I just want to make sure you agree that there was a typo in the judge's findings where he said that the testimony of the witnesses to the will warrants a finding that the decedent was in possession of the original will on June 11th, 2007. That's
Yes,
what his findings say. That's
the
a typo.
2007 aspect would be a typo.
Right.
That's correct.
It's 2003.
That is correct.
And then 5 weeks later, the decedent died.
Correct.
Okay.
That is correct, Your Honor.
Thank you.
This case further goes on to require what the sufficiency of rebutting that presumption, the lost will presumption, would be. It's a presumption which should only arise to fill a gap when there is a lack of evidence, a void, which must be filled in order to reach a just result. I would suggest that in this particular case, there was no such void, and as such, the lost will presumption was inapplicable.
Isn't there always a void, though, if the actual will hasn't been found, as it wasn't here?
Well, I would suggest that what makes this different from the traditional application of the lost will presumption is that this is not an instance in which the original will was kept by the decedent and the copy was found in the hands of a third party. For instance, an attorney or a justice of the peace or a notary, something to that effect. But rather, the copy which was presented to probate was actually found within the decedent's own home.
I know, but the original wasn't.
Correct. That is correct.
So it's still a copy. It's just that your argument is that since it was in his own home, somehow that differentiates it from a copy found elsewhere.
That's a fair statement, yes.
But are you saying that the presumption has absolutely no application here, or are you saying that the judge was wrong to say there was no evidence to rebut the presumption?
I would actually say both. And
Well, you can't really have it both ways.
I would argue that under the Aldrich case, there's language that would indicate that the lost will presumption does not arise under this fact situation. And the language which I would indicate would be found in the Aldrich case on page 170, in which the court had indicated that the copy that was found, there was no indication from the parties that it was in the decedent's possession or within his own papers upon his death. And in this situation, the copy is found within his own residence, thereby not actually triggering the lost will presumption under that analysis. Though granted, I believe the stronger argument is the second half of your question, Your Honor, in which you asked whether there was whether the evidence served
Was
to rebut
some
that.
evidence.
Yes, and in that position, I would say the fact that the valid copy was found within his own home in itself is evidence to rebut the lost will presumption. The lost will presumption does not exist in order to create an overly burdensome obstacle to overcome. It simply exists in order to create a just result, to fill that gap or that void. When the copy that was presented is found within the decedent's own home, I would suggest that that in itself creates rebuts the presumption that the decedent destroyed the original with the intent to revoke it.
Do you think that the short amount of time has any impact on this at all? It's only 5 weeks.
Yes. I would actually say that that actually cuts in favor of the proponent of the will. This is a situation where the decedent goes through great lengths in order to ensure that this will gets properly executed. He brings the will to the first notary. That was Brian Gorman, who had testified at the underlying trial, and attempts to have it notarized. Unfortunately, there was only one other person at his office when he had it notarized. So therefore, that will was ineffective. But he then goes, the next day, he brings that copy to his work to make sure that it actually does get properly executed.
But doesn't the notary, is that Frank
Francione?
Francione?
Yes.
Doesn't he testify, though, that he didn't notarize the will?
There were 2 notaries that had actually testified. The one that I just made reference to was Brian Gorman.
Right.
He's the one who notarizes the will that's not
On
a will.
the 10th,
Yes.
right.
Yes, Mr. Francione had testified at the end that he has no memory of executing a will, but rather he was under the impression that it was I believe he had stated an E-trade document, some form of loan document.
What wasn't the finding, it wasn't a lack of memory, it was that he did not, and that he actually had notarized another kind of document?
Yes, that was exactly his testimony. When I say it was my memory, it was my memory towards the E-Trade document is what I had meant to relay there. But as Judge Donnelly had referenced, that doesn't actually make it invalid, but rather makes it not self-proving.
No, I understand that, but if you add that up with the fact that the original isn't in the house, doesn't that create, I mean, it isn't overwhelming that presumption wouldn't come into to play?
The testimony that, as far as Mr. Beauregard, that is seated in this matter, he's a very private man. He was a closeted gay man who did not, no one that he worked with actually knew about it, and that was the testimony. I would suggest the fact that Mr. Francione didn't realize that it was a will simply serves to bolster that Mr. Beauregard was such a private man and simply did not want people at his work to recognize that he was leaving the majority of his estate.
Was that evidence presented to Judge Donnelly?
It was that he was a very private man and that he did not, that the people at work did not know much about him in that manner. Yes.
Mr. Bryant, could I ask you this?
Of course.
As I understand it, the witnesses all witnessed this document at the place of work, correct?
Yes, Your Honor.
Was there any discovery of or attempt to investigate what happened to the victim, what happened to his documents after he was murdered? I know there was evidence that the police had searched his home. Did they search his office?
I would be guessing, and I could not answer
So there's
that
nothing
with
in
any
the record?
It was not in the record, no, Your Honor.
But it struck me that it would not be, I don't know, but everything took place, he was employed by Raytheon?
Raytheon, yes.
Everything took place at the Raytheon offices, am I correct?
Yes, that's correct.
The notary, the witness, everything. And so we don't know anything about what happened to this man's, file, desk, pictures on the wall, whatever he did?
I would assume the police investigated that, but I would not be able to speak with any certainty, and I don't believe it was presented in the lower courts.
Let's assume for a moment that the presumption does apply. The presumption, as I understand it, is that the presumption is that the will was destroyed with the intent of revoking it. That's the presumption.
That is, yes.
The judge finds that your client failed to meet his burden to rebut the presumption that the will was failed to show that the will was accidentally lost. Is that what the burden is, that you must show that it was accidentally lost, or is the burden simply that you must show that there was no intent to revoke?
I believe it is not the proponent's burden to show that the will was lost. I don't believe there's that affirmative. Simply to provide evidence that fills that gap. And I would suggest that when the copy is found within the decedent's own home, that in fact does fill that gap. I would also
Isn't Justice Gans correct that the issue is revocation, correct?
yes.
I mean, it's not the best evidence rule that's at issue here.
Correct.
So why does it matter that it's found within his home rather than at a third party's?
I actually think it's a very important difference in that.
No, but I'm saying why.
Why? Because the trial judge went to great lengths to express that Mr. Beauregard was of sound mind when he had drafted the will and upon his death. And I don't believe there would ever be any evidence to suggest otherwise. A man of sound mind, if he were to destroy his will with the intention of revoking it, would certainly also take the other copies within his house, knowing that one's home is where search is going to take place for a copy upon one's death. And I
don't necessarily follow that. I mean, I don't think that necessarily follows.
I mean, it's our position that, I mean, if somebody.
I mean, people who are of sound mind are careless with their papers all the time.
Oh, I'm sorry, I didn't hear you.
I said people who are of sound mind are careless with their papers all the time.
Yes, that's a fair statement.
But I take it your point is that where the copy is discovered, not in the possession of the testator, there is an assumption, if not a presumption, that the testator didn't go down and track every single copy, because did what was in his or her control, as it were.
Yes, that is a very fair assessment of our position.
If we conclude that that there was some evidence, the fact that there was a copy of the will found in the decedent's residence is some evidence that rebuts the presumption, does this case have to go back to the judge for findings?
I would actually suggest no. Judge Donnelly did write a rather extensive opinion in this matter in which he found, well, let me back up for just one moment as far as Judge Donnelly had asked what this case was about in initial dialogue between the parties, what they expected to come out. And in that aspect, the opponents of the will had stated, we believe that this was a cut and paste, a fraudulently created will, as well as improperly executed. And it was on those 2 points that the trial then took place. Judge Donnelly makes very solid findings. He goes through great lengths in order to write a very concise findings in which he finds that the will that was the copy was a valid copy of the original will. In other words, it was not a fraudulently created document. It was not a cut and paste document. And that it was, in fact, properly executed. He simply, by raising the lost will presumption for the first time in his decision, essentially, that is where he made a mistake of law, and is on that mistake. If the court were then to find that that it was, in fact, there was evidence to rebut it, that the lost will presumption was rebutted, it would then fall on the opponents of the will to show other forms of intent to revoke. And I'd suggest that there was no evidence whatsoever of the descendant, or even an attempt to show the decedent's intention of revoking that will. And as such, remand would be unnecessary, because it would fall on the original 2 points of fraud and improper execution, both of which were, I believe, sufficiently rebutted.
So how is the presumption rebutted? Is it rebutted by some evidence that the will was, or that he did not intend to revoke, or do you have to show by a preponderance of the evidence that there was no such intent?
I believe it would just be by some evidence. I mean, as I stated, the lost will presumption does not exist to create this overly burdensome obstacle. It simply is to reach the just result where there is that missing void.
So it's not an evidentiary presumption, it's a presumption of going forward.
Well, I suggest both, that it's an evidentiary presumption which may be raised, and then once it's properly raised must be rebutted. I would suggest that it was not properly raised in this case, but nonetheless, the evidence suggests that it would be rebutted.
Now, just a quick question. Of course. I'm reading here from Gannon versus McDonald. Whether the presumption is overcome in a given case presents a question of fact. So if we're reviewing a question of fact on which the judge has made a finding, do we have to conclude that it was clearly erroneous?
I would actually suggest no, that you would not have to reach that conclusion. It's a question of fact whether it was rebutted. But the evidence really isn't in question. It's not a no one is saying that witness A was more credible than witness B, where the trial judge had the opportunity to hear the testimony from both people and make a determination of fact based on that. What we're suggesting is the facts are there, the evidence is the same, and that the fact that this copy is found within the decedent's own home in itself does not raise the lost will presumption. And if the lost will presumption does arise, it certainly is rebutted by that fact as a matter of law.
Okay. Mr. Bryant, you have relied on a more recent than our cases, New Hampshire Supreme Court case of 2003. Is it your position that that's in essence states what the Massachusetts rule is?
I believe that they're very close, and it is why when we were of the opinion that there was a shortage of Massachusetts opinions on this, of recent. Most of the lost will presumption cases are relatively old, and that's when we looked outside the Commonwealth just for guidance. And the King matter, which came out in New Hampshire, was much more recent in 2003. And the way that they described the lost will presumption was very similar, if not identical, to the...
And that really is, it's not exactly going forward, but what that court said is that you have the presumption, first of all, makes quite clear that the judge has to explicitly deal with it as a presumption, and then says evidence need only support an inference against revocation to rebut the presumption. And you're saying in this case there is an inference that he did not revoke.
Yes, Your Honor.
As a matter of law.
Yes, Your Honor. And I would say, as a side note...
Can I ask you a question? Do you know, are there any other cases that involve a 5-week gap between the time of a will and its disappearance and the invocation of the lost will provision?
I actually had to go to Arkansas in order to find a case that matched up on time-wise. And I believe it was cited in the brief, but it is Broadway v. Thompson. It also is an older case arising from 1919. But in that matter, there was also approximately a 5-week gap in which the original was executed and lost. And in that court, the court actually upheld the copy of the will, finding that there was a short period of time. The decedent had expressed his happiness in executing the will when he had executed it. And I would suggest the great lengths that Mr. Beauregard went to in order to ensure that he properly executed this will is analogous to that situation.
In the Arkansas case, who had possession of the original will at the time?
It was my understanding, it was when the decedent leaves that office, he had possession of that will. But it could not be found.
The decedent had
The
possession.
decedent had possession. But the original could not be found upon his death.
Thank you, Mr. Bryant.
Thank you, Your Honor. And we just rest on our.
Good morning, Mr. Talting.
Good morning, Madam Chief Justice. Francis Talty for the appellee, Raymond Beauregard, and the Beauregard family. If I might begin by addressing an important fact that I believe has actually been misrepresented in the brief and again in the argument this morning, and that has to do with the location of the will at the time of the decedent's death and in whose possession it was in.
Location of the copy?
The copy, correct.
The copy or the...
In whose possession the copy was in. The one that was presented for probate, for allowance in this case. The will that was presented by Mr. Knight. Mr. Knight, if you refer to the record at finding number 5 of the trial court's order, you'll find that the petitioner here, Mr. Knight, actually resided with the decedent.
Yes, so?
So the will, the copy was actually, I mean, a lot is made, and there's a heavy reliance, I think, on the fact that the will was in the possession of the decedent, where in fact
Well,
the
that's
will...
not a misrepresentation. That's like saying, I mean, they lived together.
Yeah.
Correct.
They were a couple.
So it wasn't that the decedent had the will in his possession at the time of his
How
death.
do you know
But
that?
how do you...
But the
it was in
police
their
found
house.
it among his papers, the decedent's papers, didn't they?
But they were living together. That was the point.
Yes.
As long as that's understood. I mean, I wasn't sure that was clear, Your Honor.
Yeah, well, if anything, it seems to me that that's rather strange. In other words, this is not some random, nephew who's, that theoretically the testator suddenly developed an interest in. I mean, this is effectively, when was this murder?
In 2003,
What date?
July.
July 19th.
So this couple could not have married, correct? They lived together. They
Correct.
would live together as a couple.
Correct.
Maybe you could just clarify for me.
Sure.
Was the will found among the decedent's papers or the other gentleman's papers?
There is no finding that distinguishes the property. Therefore, it could be equally said that it was among the petitioner's
Wasn't
property.
it found with other papers, though?
It was found actually, and I believe the record reflects, with other wills as well.
But they weren't Mr. Knight's other wills. They were Mr. Beauregard's
Correct.
other wills, correct?
Correct.
So wouldn't you say that's the decedent's papers?
They were the decedent's purported wills, plural.
Does the record indicate whether he had a safety deposit box?
It does not, and I can only assume that if he did, it would have indicated such.
Does the record indicate whether he had consulted a lawyer about the will?
It does not, and again, I would conclude that as a result, he did not.
I thought there was evidence in the record that he, in fact, drafted the will.
That's correct. But I think the question was whether he consulted with a lawyer. So I believe it's correct that it was, I'm not sure if it's in the record, but I recall that it was a computer-generated will.
Suggesting an inference that he did not consult with a lawyer.
Correct.
Now, if we can go back to the meaning of this presumption.
Yes.
Am I correct that the meaning of the presumption is that the law infers that when the will cannot be found, there is an inference that the decedent destroyed the will with the intent to revoke it?
The presumption.
Okay, well, whether it's a presumption or an inference, and then the burden shifts to the other party to prove with evidence that the inferences are sufficient to overcome that legal presumed inference.
Correct.
Well, is it a burden of is it a presumption of to the burden of proof or going forward?
I'm not sure I understand your question, Your Honor.
Well, one is if the, as I gather, the New Hampshire case can be read to say that if there's a presumption or an inference, and if the proponent of the will presents some evidence, then it's up to the finder of fact which way to go. The other is that,
Yes.
that the proponent of the will has to present evidence that not only, well, you understand.
Yes, Your Honor. I think that a reading of not only the New Hampshire case, but a reading of all of the cases cited in both parties' briefs indicate that in order to overcome the presumption, there needs to be some modicum of fact, and it's a fact-intensive analysis that you'll find in almost every one of these cases.
But here
The court
there's at least a fact, and the fact is that there was a copy of the will among the decedent's papers. Now, the judge said that there was absolutely no evidence, but that may not be right. There was at least evidence that there was a copy of the will among the decedent's papers.
Well, again, I don't believe that the court specified that the copy of the will was found among the decedent's papers. I believe that
In his house.
I believe it was found in the house, correct?
Yeah, I thought you just said among his other wills.
I'm sorry?
Where he had his other wills?
They were. I imagine that they were in the same location. They were in the house.
But I thought you said to us that this copy was found with other wills, so it was with those papers. Is that not so?
I believe this will. Well, it was among those papers, but this will, the copy that was presented in this case, was presented for probate by the petitioner. But as to what the layout of the papers, what room they were in, there isn't any evidence as to that. Just that the police did a diligent search, and in doing their diligent search, could find no original of this will.
Now, if you put aside the legal presumption, what rational inference is there that he destroyed the will with the intent of revoking it?
That in such a short period of time, that if there was a will, first of all, I think that there are facts that are in the record that show that there was a lack of knowledge on the part of the subscribers to the will, or of the purported will, and of the notary, and that those facts, which did come into evidence, were part of the trial court's overall view of the facts, which then, in the context of a very short period of time, from the time that he purportedly re-executed the will and was murdered, gave the trial court, led the trial court to the conclusion that he had revoked it himself.
You sound like you're putting some significance to the short passage of time, the 5 weeks.
Yes.
Would you explain that?
Well, I think that the idea of a lot of these cases, and the reason why I think you asked the question about a short period of time, is that most of the lost will cases are because there may be a good reason why it was lost. The passage of time is one of those reasons. People move, people reorganize their house. In a short period of time, it's less likely, I guess the argument would go, that one lost it or misplaced it after having executed it.
It clearly hasn't been found. It's not clear that it was lost. I mean, that was the import of my questions. This was a very short period of time. This was not a man who knew that he had, some serious illness. I mean, he was murdered. I don't think he anticipated. There's nothing to suggest he anticipated being murdered. He obviously had the document at his office for whatever reason. There's just no evidence about whether or not he had kept it there. But it's not as if this is an unusual fact circumstance, because it's not as if the copy is in some other place than where the decedent lived.
Actually, Your Honor, to the facts concerning the Raytheon location, and I know that one of the questions was as to whether or not the office was searched, there really is no evidence that any of the people at Raytheon knew or in any way were understood it to be a will.
But
So we don't have any
If you
evidence.
witness a signature, you don't have to witness the fact that it is a will, correct?
Correct.
And if somebody, for whatever reason, does not want to disclose to third parties the nature of what the bequest is, or to whom, and
Yeah, my point, Your Honor, was that there is no factual evidence that the original, if there was one of this will, was at Raytheon. that they may have, the notary, for example, specifically said he notarized a different document, and he detailed it in the record and had a copy of his notary record showing that he notarized something else. By the same token, the two witnesses that supposedly witnessed the will also testified that they witnessed something, but they specifically said that the decedent did not say that it was a will. Now, in order for the will to be valid, it's true that that need not be the case. They don't need to know that it was a will, but it doesn't put the will at Raytheon.
Do we know how old the decedent was?
I'd be guessing around 40s.
It was, yes.
40 years old at the time of his death.
Thank you. If I might...
I'm just
sorry,
looking at the judge. I'm sorry, Mr. Talty,
Yes,
but this
sure.
is so factually. As I understand it, the notary who testified, Mr. Gorman,
the first notary. Yep.
Brian, who didn't know, the decedent came to Mr. Gorman's workplace and asked him to notarize a will, right? Mr. Gorman didn't know. The decedent identified. Then Mr. Gorman retained a copy of the will for his records.
Correct. That's not at Raytheon, though.
No, I understand that. The copy is there. So there's no question that what was being notarized is a will, is there?
That was the day before.
Yeah, that was...
That was June 10th, I think.
Right.
The day before, correct.
June 9th.
June
Yeah.
9th.
2 days before, yeah. So, I mean, the contention is that because he attempted to execute one will on June the 9th, that he must have executed one on June 11th, and this is it.
Well, that's not a bad influence, is it?
Well, but the
Well,
copy the
but it-
police found was dated June 11th, and that's the one that the judge found was a copy of a will he had in fact executed.
And the testimony in the record from Francione is that he witnessed, or he notarized the E-Trade line of credit on that date, on June the 11th.
Right, but the judge did find that it was a valid copy of a will executed validly on June 11th,
He
did
did.
he not?
He did. Which then he concluded revoked any prior wills. But then he went on to obviously... one thing, too, that I think I need to address, although I haven't heard any questions on it, so maybe it isn't as much of an issue, but has to do with whether or not the issue of the presumption needed to be pled in the original filings. But and I think I would point the court to my brief where
I looked at that quite carefully, and I have to say, I mean, I can understand, I mean, essentially you're saying this, it's a copy, 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 but there's not an awful lot, therefore there's a presumption, therefore there's a presumption, therefore, right? It's just, it's a copy.
which raises the presumption that has to be rebutted by
But that's not what you say.
Well, it says that it must be corroborated by testimony or by evidence, which is the underlying principle of the presumption, that it has to be overcome with evidence, with facts.
And that was part of your requested rulings of law,
Well,
too, wasn't it?
yeah, the requested rulings of law were more on the point of the presumption. The pleadings, the initial pleadings, were on multiple oppositions, multiple reasons for opposition to the allowance of the will, which included in every instance that it was a copy and needed to be proved by the proponent, which I would argue arises as a matter of law in every lost will case or in every missing original will case.
I'm still struggling with the rationality of the inference. Why would somebody destroy a will with the intent to revoke it and then leave that will among his papers with other wills in his home?
I can't change the facts, Your Honor, but I mean I can argue that he didn't, and that the petitioner
Didn't what?
that he didn't leave them among his papers, but that the petitioner left them among his papers.
Oh. Based on what? What are you basing that on?
They were living together, and then afterward, I mean, the will contest contains certain facts that I'm limited to. But in the context here, they were living together. There were papers drawn up having to do with allocating some of the property to the petitioner. He was murdered a few weeks later.
There's no suggestion that Mr. Knight was connected to the murder, is there?
Well, I can't make that suggestion here, Your Honor.
Is there any evidence that the decedent had given a copy of the will to Mr. Knight?
There's nothing in the facts of this case, no.
Is there any indication of any acrimony between Mr. Knight and Mr. Beauregard before his death?
In the record?
In the record?
No.
So how can we infer then that he gave a copy? So basically your argument is that we should infer that Knight gave a copy to Beauregard, that Knight then Beauregard gave it to Knight, and Beauregard then destroyed it with the intent to revoke it, but did not collect his copy from Knight, and then after Beauregard died, Knight put it among the papers of Beauregard.
Actually, our argument in the trial record was that the will was a fabrication and put together by Knight. The court found that it was executed properly, but that the presumption was not rebutted, and that there was no evidence produced by the appellant to overcome the presumption.
Mr. Talty, let me ask you this.
Yes, pleasure.
And again, it goes back to Justice Gantz's question. I'm looking at the judge's rulings of law. He goes findings and rulings of law, then back to findings again on page 5 of his decision. And he talks about the testimony of the witness warrants a finding that the decedent was in possession of the original will on June 11th at Raytheon. So we know that that's the last place the will was seen. It was at Raytheon. He's young, healthy, fully competent, and it does not seem likely that he accidentally lost or discarded the original will. He was the victim of murder. His house was searched. Counsel has stipulated the police found a copy of the will at the decedent's home. And then he goes on to say, in light of the above facts and the short period of time between the execution of the will on June 11 and the death on July 19, I cannot draw any inference that the will was accidentally lost by the decedent in absence of any specific evidence probative of this fact. But that's not, isn't it, isn't it, he's got to find evidence that rebuts a presumption of revocation. That doesn't mean it has to be accidentally lost.
No, but he concluded that it was revoked, I believe. He states that in such a short period of time, he found that it could not be reasonably inferred that it was accidentally lost, and therefore concluded that it had been revoked.
But that's not the inquiry. It's not. It is not. Is the holder of the copy who's claiming to receive under the will? He's not claiming that it was accidentally lost. He's just saying a presumption that there was an inference that it was a presumption that it was revoked.
Correct.
Doesn't withstand scrutiny in this case.
Well, obviously, the trial court believed that it did, and we would argue that the trial judge and the appeals court were correct in finding that merely because there might have been a different outcome or a different conclusion drawn from those facts, that unless he was plainly wrong or clearly erroneous, that the findings of the trial court should stand and its decision should stand.
Thank you.
Thank you very much.